Okay, folks, ready to run again at another recorded lecture for yourselves. And this time we're going to look at navigating through legal and IP issues with respect to new startups and entrepreneurship and so on. So let's get moving down to your neck of the wood. And we open our slides. And of course we'll then enlarge them. So what I want to cover with you obviously is, as I mentioned in the intro, the navigating legal and IP issues with respect to the different types of businesses that you can set up. So our learning objectives to discuss how legal considerations can add value to entrepreneurial ventures, and then explain the most common types of legal structures available to startups. And then lastly, outline the most common legal errors made by startups. Now, I will predicate this by saying that much of the material here is American based. Okay, so there will be some differences between legal entities, between Irish law, for example, and European law and US law. But there are a lot of, from an entrepreneur's perspective, many of the aspects are similar in terms of or the concepts are similar in terms of the setups. And of course, then we need to look at defining IP and how it affects entrepreneurs themselves, intellectual property, assess the global impact of intellectual property theft, and God knows it goes on wholesale. And then explain the legal requirements of hiring employees. Now, we won't delve too much into that because I'm quite sure that you would have covered that in your HR modules, or module, whatever the case may be. But there are set procedures and legal requirements and so on. But and we won't dwell on them too much because, again, being American based, it wouldn't be very conducive to what we'd have here in Europe. And I say Europe as opposed to pure Irish because we're governed by European laws and regulations, and particularly how managing and hiring and firing employees. So one of these quotes, it says, if you desire information on some point of law, you are not likely to ponder over the ponderous tomes of legal writers in order to obtain the knowledge you seek by your own unaided efforts. So in other words, you're going to look for help. You're going to look for the legal eagles, so to speak. Any business and law students in any case. So in terms of the different types of entities that you can use, again, you have the IRS and in the US. Here in Ireland, you have the tax department, the revenue commissioners. You have business.gov, same here in Ireland. You'll have your own business RIE, business.ie, and so on. Securities and Exchange Commission, SEC in the government, and similarly you would have their counterparts here in Europe. And again, it's just to provide oversight into the legal affairs, corporate affairs of business, so to speak. And then the rest goes on, and then of course you have entrepreneurship.org, and same here in Ireland, we'd have any number of entrepreneurial sites, county enterprise boards, business angels, Enterprise Ireland, to lesser extent IDA, but mostly Enterprise Ireland will be a tremendous resource to you. Of course, then you have the CRO, the company's registration office, and you have the directors of corporate enforcement office, and so on. So you've quite a number of legal, well-established entities that can help you. So with critical thinking, laws differ from state to state, of course. So how would you go about ensuring your startup was legally set up? And what steps would you take to protect your product service? So to answer those in brief, similarly here in Ireland, you do have different entities, and you have compliance at national and European level. And of course, the real nub of all of this is, in terms of starting up your arrangement, it is always advisable that you have legal advice. hire a solicitor. There are law firms that specialize in company structure and setup and so on. A lot of the information is available online. You can do it yourself, but for the finer details, it's always worth at least having a solicitor or a lawyer throw an eye over a particular contract, and the validity of any documents that you might co-sign and sign and so on first. Because remember, for example, in the case of directors, you have some serious responsibilities of to your organization, to the employees, and to the way you conduct your businesses. And on the second point, in terms of protecting your products and services, two fundamental ways: intellectual property and patents, and of course then you have copyrights. They're the legal ways. But as I've often said to students and startups, organizations, that don't get too hung up on this, quite simply because for the most part, taking out patents is an extremely costly business. You have to take them out at national and international levels. Generally speaking, now they've eased up a little bit on some of the requirements in terms of cost and rollout at European level, but to take out international patents or global patents, you would essentially have to take it out in almost as many countries as there are legal agreements across the globe. Obviously there are a lot of countries that would not be interested with you, that you would hope not to be selling your product, but that doesn't mean that you can protect it, or that if you don't protect it, they can quite easily copy and come up with close substitutes and so on and so on and so on. And in some countries are far more enforceful, some less so, and be it culture or just plain competitive business. So one of the mechanisms, as I've always, and I've said it to you, and you guys will include it in your final business reports, is your product/service roadmap. In other words, what do you see as the next generation? So essentially what I'm saying is that you need to remain competitive, always stay one step ahead of the competition, so to speak. So the types of legal structures, and we'd have them here in Ireland and this in Europe, generally speaking, we'll have sole proprietorship, general partnership, C Corp, S Corp, limited liability companies, limited partnership, and limited liability partnerships. Much the same here in Ireland. So just to briefly go through some of the differences here. I just need my glasses on these. Sole proprietorship, so essentially there's one owner. Unlimited liability, and that's something you want to be careful of. And pass-through taxation, we don't quite have the same thing. Our tax structures are slightly different, but the same concept applies. Whatever you earn, you pay taxes on, essentially. And of course, it's simple to start up legally anyway. It's quite simple. So just by way of definition, it refers to a person who owns a business but has not formed a separate entity to run it. This is the simplest, most inexpensive form of legal structure for startups, but it is rarely the correct choice. It means the business is completely managed and controlled by you, the owner, and that you are entitled to all the profits your business makes. However, it also means that you are personally exposed to all risks and legal responsibilities or liabilities of the business. Okay, so you could lose your shirt, house, everything. So the main reason why sole partnership is the most common choice of business structures is simply that many entrepreneurs are not well versed in the legalities. But many large organizations began as sole proprietorship. For example, eBay. Pierre Oudemar, he started out, and for 3 years he was running eBay as a sole proprietor before he joined with other partners and so on. And as I say, the rest is history. Then we have general partnership, and just bear with me. And in the context, 2 or more partners, so they have unlimited and joint liability, and again pass-through taxation. So we'll allude to this pass-through taxation now in a second. So a general partnership involves 2 or more people who have made a decision to manage and share in the profits and losses of a business. So like sole proprietorship, setting up a general partnership is relatively low cost and straightforward. So each partner reports profits and losses on individual tax returns rather than at corporate level. So and that's known as a process of pass-through taxation. So taxes are paid at your personal income tax rates. So you declare, you have the usual allowances and all that sort of stuff, and you pay at whether it's 25, 27 or 42p in the pound, and plus you have all your other liabilities or tax commitments, USC and so on, all of those, and you're given your standard tax credits. Probably one of the advantages, you might be able to write off some more expenses against your profits and, you know, improve the bottom line so you have a bigger share out. But in terms of tax, you might be able to reduce your personal taxation because of additional expenses incurred through the business. So for example, you say if you started up a cafe, so to qualify for general partnership legal status, you and your partner must be involved in the business and contribute towards setting up and paying the costs of running the cafe. So you and your partner will split the profits and losses between you. Straightforward in terms of a general partnership. So now we're moving into the higher realms, and this is what's known as a C Corp. So you'd have stockholders, directors and officers of the company, and again you have limited liability. It's a taxable entity as an organization, and you have potential double tax on dividends. So let us just go through the descriptor of this. A C corporation, sometimes known as a C Corp, is a separate legal entity created by the state government and owned by an unlimited number of shareholders. This means that the corporation, not the shareholders, is legally liable for its actions. So the most money that shareholders can lose is their personal investment. So there's a limitation there, which essentially is the value of the stock that they've bought in the corporation. Another advantage to the C corporation is transferable ownership, which means that it can issue shares to investors in exchange for capital, cash. In addition, because the corporation is a separate entity, it benefits from continuous existence, which means that it will still survive after the demise of its owners. This allows the corporation to plan for the future. So owners, founders often sell out. They would have an exit strategy, and the exit strategy may mean that they will sell their shareholding in their company to other investors or to other potentially business growers for all intents and purposes. So founders often are the brains behind the idea, product or service, and they can only take it so far, and they need to get in professional managers. Sometimes they don't want to take on the role of managing the people, that they like to stay in the front end of the R&D side of things. Therefore, they will bow out or sell on their shares to another company, or it could be a buyout from a competitor, a larger organization, and so on. But they may remain on in the company as advisors, possibly as directors, or as working to continue with their passion and their hobby, which is developing products or services. And then we have what's known as the S Corp or S Corporation. So again, you have stakeholders, directors and officers. So they have limited liability pass-through, but subject to eligibility requirements. So what does this mean? The S Corp is a corporation whose stockholders elect special treatment for income tax purposes. So for all other purposes, it is identical to the C Corp. So in order to qualify as an S Corp, the corporation must be US domestic and have not more than 100 shareholders, who in most cases must be individual US citizens or legal immigrants, not corporations, partnerships or trusts. So, and all of whom must own only one class of common share, which you would know as ordinary shares. So unlike the C Corp, the S Corp does not have to do with double taxation, as there is only one level of tax to pay. Similar to partnership, the income and losses are passed through the company's shareholders' tax returns and taxed at the individual rates. This is especially attractive for corporations expecting to lose money which in the short term, as such losses will offset other income earned by shareholders, so acting as so-called tax shelters. S-corps often consider a later switch to C-corp status because their growth may be limited by the restricted number and types of shareholders permitted. So another reason for switching to C-corp status is the fact that the S-corp's future retained earnings would be taxed to stockholders and so-called phantom income. Earnings are taxed but are not received by the individual. So that's a little bit more of a complicated scenario. So generally speaking, our equivalent in Ireland would be more towards the C-corp. Okay. Now, if we look at the most common type of setup that we would have here in Ireland or Europe is the limited liability company. So you have members and a board of managers, which is optional. Limited liability, pass-through taxation, again, your personal taxation, you're paid, you have a remuneration, and you may elect to become a taxable entity. So looking at the precise descriptor, a limited company is a business structure which combines the pass-through taxation aspects of the partnership with the limited liability benefits of a corporation without being subject to the eligibility requirements of an S-corp. This means that profit and losses are reported on individual tax returns. Therefore, double taxation does not apply, and there is potential tax sheltering from losses while personal assets are protected. That's the key point. Limited liability. Modern limited liability company status allows LLCs to have continuous existence similar to corporations. And just as with partnerships and corporations, it is advisable for LLCs owners, called the members, to enter into ownership agreements, often contained within an operating agreement which serves as the combined purposes of bylaws and stockholders agreements in corporations. So LLCs are rapidly replacing the S-corps by choice, and that's absolutely true. We find that they're the most prevalent type of company structure nowadays anyway, certainly in Ireland and in EU, and obviously in the States that move towards that, the whole point being limited liability. But be very careful, because you do have directors. You need at least 2 people to act as directors, and they must be domiciled in the country of registration. As in the case of Ireland, they must be 2 Irish citizens. And they could be foreign nationals, but as long as they hold Irish citizenship, they can set up a limited liability company. And the next entity is, of course, limited partnership. So general partners and limited partners. Unlimited liability for general partners, limited liability for limited partners. So again, pass-through taxation, and limited partners prohibited from management. Okay, so just a brief detailed descriptor of this. There are a variety of other forms of business entity which may be used in certain circumstances. One example is the limited partnership, a pass-through tax entity made up of 2 kinds of partners: general partners who manage the business but have personal exposure for its liabilities, and limited partners who are essentially silent investors but are protected from liabilities. Okay? And that can often be the case. You can have a board of the shareholders can form the management board of the company, and you'll have essentially what are known as executive and non-executive directors. The executive directors are the day-to-day managers and directors of the company. Non-executive directors are not directors by legal definition. You need to double check that, but generally speaking not. You can have things like shadow directors, de facto directors, and so on. But be careful. Do your homework when you're calling yourself a director, and you have to register yourself in the memorandums of agreement and association, articles of association, and so on of the company. When you're legally registering the company, there has to be a list of directors, and the Office of Corporate Enforcement are very strict about compliance and so on. So there's a lot of responsibility by taking on the title and registering yourself as a director. Just be careful of that one. So limited liability partnership, have this is the limited liability partnership. So 2 or more partners, which I've kind of basically just described. Limited liability with some restrictions, and typically professional practices. Dental practice, what do you call them now? The health centres that you have now. You have a group of doctors, and you might have a group of doctors and a group of dentists together in one of these primary healthcare systems. That would be a limited liability type partnership. But in actual fact, these are owned by corporate entities, as it happens. But in a smaller structure, yes, you can have 2 or 3 people running a small architectural firm, for example, and they'd have limited liability partnership. So there are a variety of other forms of businesses which in certain circumstances exist and so on, such as the limited liability. Is there anything of particular? Recently, however, the limited partnership has been largely replaced by limited liability company. It acts as a pass-through entity, grants limited liability to all members, and does not prohibit any member from getting involved in management. And that's a key, because again, it means you don't have to be a director to be included as a manager, in the management team. You might have special skill sets or special expertise that they might draft you in and include you in the partnership, and you will have limited liability. And then benefit corporation. So stockholders, directors and officers, limited liability, either S Corp or C Corp, and charter sets social purpose. So really what you're looking at is a charity for all intents and purposes. So a benefit corporation or B corporation as a form of organization certified by the not-for-profit B Lab, as they call it, which ensures that strict standards of social and environmental performance, accountability and transparency are met. So B Lab certification ensures that the for-profit company fulfills its social mission. It is available to businesses operating as any one of the business entities mentioned previously, such as the corporations. And in addition to the B Lab certification, many states, obviously in the US, have enacted statutes creating a new form of business entity, also called B or benefit corporation, which is not subject to fiduciary obligations and other business corporations. So a B corporation or a benefits corporation must justify all their actions as contributing ultimately to increased shareholder wealth. So yes, bear in mind you have the 2 types there, the not-for-profit and for-profit B corporations. And what else do we have on the entities? The most common legal mistakes that we see. Choosing the correct business structure. Now again, you saw that oftentimes they start out as sole proprietors, and usually if you take, for example, an electrician, he decides to set up his own little company, that can be a sole proprietor operation. But as he gets more and more customers, he might decide, well, I might hire on another 1 or 2 apprentices. Fine, you have responsibility for their well-being. Remember, you've no limited liability. So if one of those apprentices was electrocuted and you didn't have insurance, you're going to lose your shirt, house and everything you possibly own to cover the costs. But on the more positive side, as a sole proprietor of the small firm, but business begins to grow and grow and grow, and you decide, I need to get another electrician or 2 and to work with me on this. So you might then decide to form a partnership, and then you move on, and the bigger the firm becomes, eventually you'll come up to a limited liability company, and you can have directors in multiple types of electrical business and kitting out houses and factories and so on. So the company grows over time. So as long as you're aware that you need to move on and limit your own personal risk, having the right legal structure. So accepting free advice from family and friends, they're not lawyers, and this is one of the points very much in favor of solicitors and lawyers. You do need to seek legal advice on the structures of your companies and sign partnership agreements and the way the profits may be split. You may have a structure where it might be 70-40. You have a controlling partner or a majority partner as such, holding a majority of shares. Do you actually dilute the shares in proportion to the percentages that you have? So the 70-30 split. If you offer another 100 shares to a new partner coming in, do you split your shares? I have to give 7 of my shares or 70 of my shares, and you have to give 30 of your shares. So all of these legal entities, sometimes the founder doesn't dilute his shares. He may just hold 51 or 52%, but he said, that's it, I'm not losing control of my company, but all other expansions and share issues are taken out of the remaining 49% or 48% of the shareholding in the company, which means that you might have 4 directors, 3 directors, 7 directors or senior managers. All their shares become diluted, so they're losing essentially value in the company potentially, but the whole idea is to increase the value and the shareholding value of the company, so everyone wins. And of course, unclear or missing written agreements. Quagmire, but sure, we agreed on, we shook hands on it, and we spat and shook hands. Doesn't work in a court. As I say, a courtroom is the coldest place you could be. There are no emotions. It's just pure fact and data. Do you have an agreement? No. But we talked about it and we're best friends and all this. Doesn't matter. Do you have a written agreement? No. And then vesting schedule as such, but what are the vested interests, which kind of I covered by talking about the split of the share issues. So 4 types of intellectual property. Moving on to the other learning outcome. So you have copyright, trademark or a service mark, and then you have a trade secret, and of course you have patent. So number 1, critical thinking. How would you protect your startup against patent trolls? Now, what the hell are patent trolls? Well, essentially they are people that are constantly scanning database of the patent organizations. Each country would have a centralized patent organization. It's a legal repository of all patent diagrams, descriptors and so on of potential new products. Now, patent trolls are people that actually scan. So you might file a patent and the patent might be expiring in 5 years time or 10 years time, and you haven't done anything about it. There's some fantastic piece of equipment that you're thinking of developing, and you said there's something really unique about this, I'm going to protect it. Patent trolls are watching these and say, Marcus filed a patent, he hasn't done anything for the last 4 years, this patent expires in next year. As soon as that expires, I'm in and I'm going to take a copy, or I'm going to use that patent, or I'll file for usage and so on. So you lose your idea. Now, I hands up, I don't know, but is there a time limit on these patents? Sometimes you take them out indefinitely, but that can come at a cost. So do you think individuals or firms have the right to hold patents without producing products of their own, and why or why not? In the larger organizations, large multinationals and so on, you would see companies taking out patents simply to protect their existing products and say that our next generation are going to use this and this type of technology, and that's used to give them a level of protection. It could be 3 years, 5 years protection, 7 years protection, but other companies or the competitors say, well, we can't do it that way because they've already filed a patent for that combination of technologies. We can't use that, we'll have to come up with our own, and it becomes more costly. So is it right to do that? My response would say, yeah, fine, do it, protect it, give yourself some breathing space, and but to sit on it and not use it just for the sake of taking out patents, hoping that somebody might breach it, that's unethical. So what are the effects of patent trolls on startups? Oh geez, patent trolls, they could be looking at you and see that you can only have a limited patent, and you might only have a national patent taken out. They say, well, hang on a sec, quick, get into the UK or get into Germany, take out a patent on this, or develop that product very quickly because we're not breaching the patent. Well, you might be under European law, it could be a bit risky, but go outside the EU and say set up a company there very, very quickly. Mark Ashton's company has a patent on some new artificial intelligence software and hardware that will help improve student retention and engagement. Oh God. But they could go off and say, we have the resources, he's only in a startup phase, he won't be able to produce this for another 2 years, and we can have this up and running in 6 months, 6 to 12 months. Go to Saudi or Dubai or Pakistan or India or Taiwan and set up the company immediately. The resources are cheaper, and boom, there goes your patent. So patent trolls can be watching it, so you've got to be very careful. That's why you see, even though the patents themselves are quite detailed, oftentimes there are certain key elements left out of the patent, such as say, well, I can see how this is happening, but it doesn't quite make sense. I don't know how they're using this technology or how they're putting it together. There's something missing, and it's the key ingredient, perhaps. But it does work. It does work in terms of protecting yourself to some degree. And also, what's really advantageous of having a patent or some form of copyright or trade protection and so on, it becomes extremely attractive to investors, because they know then that the competition technically can't get in because you've got your product or your service protected, and that in itself is almost cash in the bank. You have an awful lot more to bargain with as a startup entity. So resources for IP information. So you have Patent and Trades Office in the US Corporate Copyright Office, and Invent now, and Google Patents is another place. And interestingly, one of the big issues that came out last year was Digital Rights Management Act in the US, and it's spilled across globally now. But essentially it's YouTube and digital rights management. So if you release music or you play videos, and let's just say that I downloaded something from a website and I upload it onto YouTube, you can be hit with what they call it, there's up to 3 strikes. So I could be told, sorry, you can't use this for monetization, you can only use it for your personal use, or you can't use it at all. So you will get it. So they've put in very powerful algorithms to check that anything you've uploaded doesn't breach the original owner's rights, trademarks or copyright, predominantly music and video. But even more interestingly, YouTube, Google has come out with another. Yes, they want to include newspapers and journalists and so on under their copyright law. In other words, that they get money for everything that's produced and so on. So and if you remember in the news not so long ago, several weeks ago, Australia said, no, we're not doing that, we're not paying these rights, and Google started to close down some of their facilities to online facilities in Australia, and said, okay, we're not publishing anything belong to you from your national broadcasters and so on. So there's a bit of an issue there where and this is a classic situation where a global entity is taking on national governments. It'll be interesting to see how that pans out, but it's becoming very, very litigious, this whole area. So there are, in the case of YouTube, for example, and its protection of copyright and so on, which, in fairness to them is fine, but people are finding that videos that they had up years and years ago are suddenly becoming they're getting strikes, and one strike it takes 3 months literally before they lift the strike. And if someone said, Mark Ashton, that has a piece of music up belong to me, I want you to take it down, you may have so many followers or hits and so on, YouTube will immediately take it down and say, strike one against you, Mark, for having uploaded that piece of video or that piece of music. You don't own it, and therefore you can't be using it on your site. So clearly I'm very careful about, for example, background music. there's a whole industry after opening up where they're publishing copyright free music that streamers and YouTubers and so on, for example, can use without being in breach of the existing rules. And also there's been a number of other platform sites have opened up, Odyssey, Discord, and so on, Twitch, all have opened up, and they're gaining traction because people are pretty ticked off about the way YouTube are suddenly striking people or issuing copyright breach notices and so on. But remember, YouTube they have simple algorithms, or complex algorithms to be honest with you, in place to protect the artists and the owners of it, because they're a profit machine. They don't care, doesn't matter if Mark is teaching students or not, he shouldn't have used that piece of material, and so on. So it's getting quite in other words, the software is doing a lot of the work that technically before would be the responsibility of law firms having to go out, pad to PDF, resources for other information, Inventors Digest, Patent Wizard. So these are just applications where you can actually find out more about patents and resources, the information, and get some more background on various patents and so on. And common IP traps, as they identify it. So publicly disclosing innovations, failure to protect product and processes, inability to determine originality, failure to assign ownership, and then failure to protect IP in global markets. So many of the points I've already discussed, such as the IP in global markets, it is a costly business, so you want to have deep pockets. And as a startup, generally speaking, that's a waste of money. It's too perhaps not if you're in the pharmaceutical industry. You might have a new drug, but you do have exclusive worldwide protection for 7 years from the time you file the patent. So, but the first point becomes extremely important, and particularly for you guys as entrepreneurs, business startups, don't talk about stuff. Don't be chatting and bragging about stuff, because people will be listening and will pick up on your idea, and before you know it, there's a product out there. We had it with a group of students on this same module, must be 6 years ago now at this stage. There was a group of 4 young ladies on the same team, and they were developing a timetabling app for our students in AIT. And literally the day before, I think I might have been telling you this, so I'll make it short again. The day before their assignment was due to be uploaded onto Moodle, they met me under the archway outside the adult ed area there, and God love them, one of them was actually crying because they had that morning, one of the software engineering students, I think he was a master student up in the Software Institute, he released a timetabling app, which was quite good. It lasted for a couple of years. I haven't seen it since. I think he left, but it was essentially what they described, and they were panicking. They said, God, what are we going to do? We don't have time to rewrite or come up with a whole new idea and so on. I said, and the good side of it, or the upside of it, was, I said, that's not the problem. I said, your lesson, did you talk to, well, we were talking to engineering about how would you do this. I said, there you are, lesson learned. Don't talk. But I said, in terms of your assessment, if you were a startup, that would have been a disaster, clearly. But what I'm evaluating is the fact that you've gone through the process and that you understand the process. That's what I'm evaluating, not the fact that somebody stole your idea, potentially. You could never really prove that. But we also had another situation where we had a student developing a product, had formed a company, was working in the Entrepreneurship Academy or using that platform, and while up at the investors pitch up up at the RDS, didn't pass the lecture. Said, hang on a second, you use that as part of your assignment, and as such, the college owns that product idea. And I went, wow, you never told me this. Did you use that as an assignment? Well, not really, it's a slightly different version of it. I said, are you absolutely sure? Have you got your assignment? You need to be absolutely careful on this one, because if it was her assignment, then technically the college owned the intellectual property, and rather than her setting up the company, she should have had permission or license the concept back from the college, even though she would have thought about it writing her assignment. or team assignment at the time. So you've got to be very, very careful in what you say and where you say. And that's probably the most important point in relation to the traps that you can fall into. And then failure to protect it and not taking out patents or putting it on the long finger. One of the most simplest ways of taking out a protection is having your diagrams, having your detailed descriptor of it, putting in a seal envelope and putting it in a bank, into the vault. And if 3 years down the road someone has stolen your idea while you were trying to develop the product prototype, you can actually go back, and because it's dated timestamps, you can prove that you had the idea before this other company, and boom, case won. It works. So legal requirements for hiring employees. As I said, I'm not going to spend too much time on this because you would have covered it. So equal employment opportunities, and all that sort of stuff, unemployment and workers' compensation, your tax commitments, social welfare commitments, company's contribution to PRSI, peer-related social welfare insurance, and all that sort of stuff. The company pays such a percentage, and to make sure that the company pays its element of taxation and social welfare payments, insurance back to revenue and the Department of Social Welfare, and also that they're paying their taxes, such that when if you move on, that you've actually proved that what's your P60 or P40s or whatever they call them now, that are issued automatically now. You don't get them, they transfer with the employee from each employment to the next. So these are the obvious things, but you do have legal, and even the process of hiring and so on, the issues around diversity, inclusion, and equality. So be careful of those requirements, and particularly if it's in the public sector area. So legal requirements for hiring, so withholding taxes, for example, employee forms, benefits, and social and safety measures. That's again, that people are given proper induction and training, particularly if you're working in a manufacturing environment or in a pharmaceutical environment, wherever you're using process, or even if you're working in an office, how to use the equipment that you're going to be using as part of your day-to-day routine. So you have very precise processes in place, and they're there to protect the employee and the company. So critical thinking question: why is it important to protect intellectual property? Well, I've just said that. So you can protect your future, the future of your company. Whose responsibility is it to protect the intellect? The owners, founders, managers, directors of the company. Don't leave it too long. Get out there, find if it is patentable, and register the patent. And when is the best time to apply for intellectual property protection? That's a good question. When is it? As a founder or someone that might have had an idea, if you can ascertain as quickly as possible the USP of your product, why is it, and what part of that USP is so unique that it's worth protecting, the sooner the better. And then of course looking at the patent time. If it says 5 years, will I actually be able to convert this idea, USP, unique selling proposition, and the patentable part of that, will I be able to convert this into an actual prototype and a product for sale within 5 years, for example, or 7 years, whatever the term of the IP patent protection is. The longer you leave it, the longer, so when the clock starts ticking, do you say, well, if I can get another year before I can patent, then I get 7 years after next year, or I have to take it out immediately, so the clock starts ticking from now. So just watch that space in terms of the patents. I don't need to go through these are very pretty much US driven, but you do have all the same in Ireland and EU law. So the types of employees, quite simply, employees, contractors, unpaid interns. God love you, some of you will do that if you go on placements. Usually companies do pay something. I know that certainly above up on the DCU internship program, which is for third year business students. They have to spend 6 months, one whole semester at least, and sometimes 2 semesters working in companies. Some of these people earn 35, 40, 50,000, strangely enough, in some companies But that's all very fine if you're living up here or living in Dublin and so on. You have a choice, and it's a very structured, and it's been around for years, actually, many years. So they've built up a whole department around those internships. But nevertheless, they do exist, and oftentimes it's just the experience is the value itself, and that's what you get onto your CV. And then, of course, you have volunteers. Fools. No, I'm joking. Yeah, volunteers. And that's essentially it, folks. On the IP, as I said, there's not an awful lot. Technically, there's not an awful lot. I was saying technically there's not an awful lot in it. Was a short and sweet, 45 minutes give or take, but nevertheless it shows you some of the key points on protecting your product and your product ID or service ID. More difficult to patent or copyright services as such. Certainly physical products are tangible, at least you can show and prove them, and so on. So that's it. Again, as I said, this is an asynchronous version of the lecture, and on that note, I'll let you go, and we'll look forward to the next one, and we'll upload it onto YouTube. Take it easy, folks. Bye bye.